Your home with Buildaid on Mix 93.8. Proudly brought to you by AfriSam. AfriSam, creating concrete possibilities.
Your home with Buildaid on Mix. Tonight we are dominating, all the females are dominating in the studio, which is always an exciting thing. So it's just Kay and Simon in the studio tonight, but yay, he's excited because he's got lots of chicks surrounding him. And we're very excited as well because we've got Chantelle Gladwin from Schindler's Attorneys talking to us tonight, and we just happen to have this amazing specialist online, and we're going to be talking about the buzz that's been happening today in the news on social media about purchasers who can be held liable for sellers' historic debt. And that doesn't sound very exciting at all, but I'm sure you all want to know about it. We're also going to be asking you to give us the name of the band, and we're going South African tonight. So I'll give you a little bit of a clue. They were around in the 80s, and they won the East Rand Battle of the Bands in 1978. They were pretty funky. I'll give you a really easy clue. One of their songs was Taxi Man. So if you know the answer, you know which band we're talking about, SMS us on 41. Chantelle, thank you so much for coming to speak to us tonight. And as I said, we're really excited. We were going to talk about, well, we are still going to talk about disputes that you might have with your contractor or between landlords and tenants. But first, let's talk about what's been going on in social media and all over the news today. Well, you can elaborate on what this thing is, but it's basically that purchasers can be held liable for sellers' historic debt. So it's sort of, if you sell a piece of property, you're free and clear, but the person who buys it could be paying your debt to the municipality for up to 30 years, or from 30 years ago.
In a sense, yes. So I'll explain in just a minute exactly how they came about. But just to note that the seller is not free and clear. The debt still exists when you sell the property, and you are still liable for it to the municipality. But the municipality may, for reasons of convenience, choose not to come after you for that debt, but may rather go after the purchaser, because the purchaser is the owner of the building, and the building is what actually stands as security for the debt.
Okay.
The building or the land. So it makes sense for the municipality to go after the land, which unfortunately happens to be in the purchaser's hands. So what would happen is that the municipality would attach the land or the building, sell it, and then take the proceeds to pay off the historical municipal debt.
So basically any debt that is attached to the land belongs to the land, basically, it stays with the land.
Exactly. So this all came about because there's a piece of legislation called Section 118 of the Local Government Municipal Systems Act. And this has been around for a long time, it's nothing new. And what it does is it provides that as a seller of a property, you have to get a rates clearance certificate from your municipality before you can transfer the property to someone else. So there are two types of rates clearance certificates you can get. The one is called an abridged certificate, and this certificate you can get if you only pay 2 years worth of your historical debt. So if you have not been paying your rates and taxes and your other services for, let's say, 10 years, you can still get a certificate and transfer your property if you pay 2 out of the 10 years, but then it means there's 8 years unpaid, and that attaches to the property, which will follow the property into the hands of the purchaser.
Yeah, we spoke about that a couple of, a year ago or so, saying that it really is a good idea to get a full clearance certificate rather than an abridged one, because there could be outstanding debt.
So the other type of certificate you've already mentioned is a full clearance, and that's where you pay absolutely everything outstanding on the land. And as a purchaser, you definitely want to insist that your seller is getting a full clearance. It's your best line of defense against being faced with a problem. It's not a guarantee that nothing's going to come out later, but it's the best start that you can make.
So full clearance, Chantelle, just to clarify, we'll go back to how long?
Hypothetically, it's everything. Okay. So if there is any debt attaching to the land from even up to 30 years ago, it will be included in the amount that the seller needs to pay when he gets a full clearance certificate.
Okay. So, I mean, we were saying a couple of shows ago when we were talking about this that it really is a good idea to get this full clearance. Now, it's a no-brainer. You have to. Abridged isn't going to cut it at all.
So this all sort of blew up about 2 years ago when the municipalities started getting a little bit more aggressive, and previously they hadn't really been pursuing purchasers for sellers' debts. but they started wanting to do it about 2 years ago. And the first case that came about on this issue was municipality, which was the first time when our courts were called to interpret Section 118 and to answer the question of whether a purchaser really can be held liable for a seller's debts. So in short, since municipality, there have been a series of cases which culminated with this one, which was the Mitchell case in the Supreme Court of Appeal heard on the 29th of Jan. And this case definitively said that purchasers can be liable for sellers' unpaid historical debts.
That's absolutely astounding. We're going to come back and talk a little bit more about that. If you have any questions on this for Chantelle, do SMS us on 41348. So Chantelle, let's just go through, I mean, we say on the show all the time, plan, get a good contract, all those things. But let's talk about why it is so important and really what constitutes a contract. What does it mean? Basic.
Okay, so I think the first myth that we need to dispel is that in terms of South African law, a contract does not only need to be in writing. You can obviously have a written contract, but if you make an agreement orally, it is still a binding agreement. It's like a promise. If you break it, you could be held legally liable for that. So if you have an agreement and it's been reduced to writing and signed by the parties, it's pretty good evidence of what the terms are, of what you actually agreed to. But if you have an oral agreement, it's much more difficult to try and prove what the terms are, because you're going to say X and I'm going to say Y, because it suits us to do that. So oral agreements are binding, but they are very difficult to prove. And that's why we say, put it in writing.
Yeah. Well, nowadays,
keep a
with
paper trail.
recording devices, I'm assuming that if you record a conversation, would that stand up?
It does. There are limits to that though, but let's take an agreement, for example, concluded over SMS.
Mm-hmm.
That would probably be found to be a valid agreement, as long as all the requirements of an agreement in our law are there. So we have a couple of sort of absolute requirements in our law that you can't get around. So for example, you have to have offer and acceptance. So the contents of the SMSs have to show that I made an offer and you accepted it. And then, there are a couple of other requirements. I'm not going to go through all of them now, but as long as they're all there, then you will have a binding agreement. So an agreement over SMS is it's not really an oral agreement, it's more an agreement in writing, but the chain of SMSs would then prove as your agreement. So,
but you can sort of fudge those kind of things.
Absolutely, you can.
Yeah.
Emails as well can be altered.
Yes.
When you forward an email, you can usually alter the chain previously
Yes.
and make it look like all sorts of things happened that actually didn't.
Yeah.
And we see quite a lot of that in our business, in fact. Not affecting us, but affecting our clients.
Yeah.
You pick these things up as you go along. And it's a sad reality, and that's why not only must you reduce the terms of your contract to writing, but the parties need to sign it. And there's a very, very important clause which goes into most contracts, which says that we cannot have any alterations or additions to this contract unless it's reduced to writing and signed by the parties.
Right.
Because of course you can fake a signature, but it's much easier to prove that a signature's been faked than an email chain or an SMS or something else like that.
Which is why you need witnesses as well. I mean, it's the whole thing.
Yes.
It's just creating this circle of trust, and we're all in agreement that this is what was said.
Yes, and it's about the evidence, If you are going to enter into any contract, whether it's a sale of a house or a renovation that a contract is going to do for you, any contract that involves a significant sum of money, you really need to make sure that your paperwork is in order, because if something goes wrong down the line, you're not just going to lose a couple of thousand, you're going to lose hundreds of thousands.
Yeah, absolutely. Now, within this contract, we say it all the time on the show. Have one. It's really important.
Have a written one.
Have a written one.
And something that's worth the paper it's written on.
Absolutely.
Don't copy and paste it off the internet. Don't go to a cheap one-man show attorney who just got his degree yesterday.
Absolutely. Yeah.
What you're going to get, although it might be cheap, is not really going to protect you.
Well, when you look at the intricacies of contract, you realize then why lawyers are important. Besides all the Latin terms that are used, it really. You said something earlier when we were chatting before the show. Something about read every line.
Right. So there's a fancy Latin phrase, caveat subscriptor, and it's basically the one thing they drill into you at varsity, and it means signer beware.
Okay.
You literally have to read every line, because once you've signed it, you are bound to it. There are a few exceptions, but by and large, When you sign it, you are bound. So make sure you know what you're signing.
Absolutely. I think we all a little bit flippant about signing a contract. So we're going to play out with Taxi Man, and the band we were looking for was Void. And as we said, we believe they might still be active in London. So if you're over there at any time, check out the Springbuck Bar, and you might just see them in action. Quite interesting. And this is us for this week. We'll be back next week with the Buildaid Show, brought to you by AfriSam. Good night.
Your home with Buildaid on Mix brings you all sorts of interesting info about building. Graham Alexander chats to different guests every Wednesday evening between 6 and 7. Proudly brought to you by AfriSam. AfriSam, creating concrete possibilities.